Welcome to our second Practical Knowledge Series seminar of 2018, organized by BioStrategy Partners Incorporated. BioSP is a nonprofit consortium of academic medical centers and research institutes committed to the development and transfer of academic research into the marketplace. BioSP also develops and offers programs and services to foster industry academic collaboration, aid technology development and commercialization, and contribute to the ongoing education of faculty and graduate students about commercialization and technology transfer processes. I also want to take a moment to recognize our sponsors. We have Riverside Law. Riverside Law specializes in intellectual property and has a diverse team of professionals with scientific backgrounds suitable for nearly any technology. And also MVM Associates. MVM Associates, located in Fort Washington, PA, is a leader in securing and managing a variety of tax and grants for companies throughout the U.S. So today's topic is Bench to Bedside, Intellectual Property's Roles in Translational Research. So we are going to navigate the intellectual property process to enable you to better understand intellectual property's role in advancing your research and inventions from the bench to the bedside. At this time, I would like to take a moment for each of our panelists to introduce themselves. Jianbo, you want to start with you?
So Erika and Michelle, thanks for this opportunity. So my name is Jianbo. I started my tech transfer career at the National Cancer Institute. So I did 5 years of fellowship there, and then I moved to Oregon State University to manage their life science portfolio and a little bit on chemistry and physics and a lot of microfluidic stuff. It's always my desire to work in a college of medicine settings. So it happens there's an opening here, so I applied, and I'm very fortunate to have the opportunity. So I came here since September, and I really enjoyed working with the faculty members here. So hopefully a lot of technologies will come out of here. Thanks.
And Pat, how about you?
Yeah, hi. My name is Pat Kelly. I'm a partner of Riverside Law. I got a PhD at Georgia Tech in 1991 in molecular biology. I was in a biophysics lab, and I found out I could take the patent bar without being an attorney. So I did the first and most important thing. I bet my wife I could pass the exam. And I took the exam and became a patent agent. And soon after, I got an offer. I finished my PhD, got an offer with a 100-year-old patent boutique in Philadelphia. And so I started there in 1991 and have worked mostly in the biotech area. Like I said, our practice covers everything. I also did 2 stints on site for a pharmaceutical company and then a medical device instrumentation company, and kind of got to see things from that side as well. So I was kind of loaned out to them during my career, which is actually very helpful because you see things from the other side. And we work closely with Penn State here, and just let us know if you have any questions during the panel.
Steve?
Great. Yeah, thanks for the opportunity, Erika, to be here, and it's great to be with you today. My name is Steve Faithful. I'm the Director of Business Development at the Ben Franklin Technology Partners. If you haven't heard of the Ben Franklin Technology Partners, we are a state-funded organization that provides early-stage investment funding, mentoring, and training and help for technology or technology-related startups here in the Commonwealth. My background is software development, started and exited a software development company out of Lancaster, exited back in 2013, and then joined Ben Franklin to help other startups within the Commonwealth, start, get funding, stay in the Commonwealth. And we're closely related with Penn State. And so a lot of the companies we see are coming out of research, coming out of the university. And then I also spend a lot of time just on the street looking for startups, working with entrepreneurs, certainly, and IP is a part of that.
Thank you. All right, and I'm Erika Swift. I'm the Associate Director of the Center for Medical Innovation here at Penn State College of Medicine. Before joining Penn State a little over 2 years ago, I spent over 15 years in industry, both in consumer and dental products and also medical devices. One of the many roles I had in industry was being part of new products teams, where we license technologies from academic institution and individual inventors. Many successful negotiations resulted in bringing profitable products to the market. I also got to witness an agreement that went really bad, and it ended up in federal court, and ultimately the inventor lost his patent because the court ruled that his patent was unobvious, so due to obviousness. So it's really wonderful to see all of you here today taking active interest in intellectual property. Understanding the fundamentals of IP will enable you to make sound decisions regarding your research, your discoveries, and your inventions. So please note that we welcome audience participation. So as we're discussing the various components of intellectual property, please feel free to ask questions. And that also goes for those of you who are watching us via Zoom. Feel free to type in the chat box your questions and we'll get to those as well. So let's get started with some basics. So I'm going to address the panel for the answers. And first and foremost, what is intellectual property or IP?
So it covers a spectrum of different things. Mostly here at Penn State, I think where you're going to see are issues that relate to patents. So it's a situation where the government has set up a situation such that if you invent something and you describe it to the scientific community in general, so that with specificity, so someone can take what you've discovered and learn it and apply it, they're going to give you a right back. It's an exchange. They're giving you essentially a limited monopoly of time and space. Time is the patent term, space is the United States. So in exchange for teaching someone how to practice the invention, which means the patent application has to describe it with enough details so someone can replicate it, they will give you this right to enforce that patent throughout the United States during the patent term. So this whole thing was provided for in the US Constitution, and think of it as kind of an exchange. There's a burden on you to make this honest teaching on how to replicate what you've done, and in exchange you get the right to enforce in courts the patent claims. Copyright is something else you encounter all the time with movies and music and books. That tends not to be something you're going to encounter so much in this context. Maybe sometimes with software and stuff, but copyright's really not that much an issue. The final issue is trademark. Trademark can be very important because trademark is intended to create a connection between a good and, say, a symbol. So everyone knows Nike or Campbell's soup, whatever. People start to associate certain qualities with a good, and that can take a long period of time and a lot of investment. So, like if you start a company and you want to have a good, strong, client base, you want to work hard on quality control, for example. So when people go to buy your product, they know it's always tastes the same or it always has the same qualities. And once they start to make that association, there can be a very strong value to a mark. The concern for you as the company owner is if someone else, let's say you come up with a symbol, it's a marshmallow with a halo, let's just say. Someone else decides, you know what, they're doing great in the market. I'm going to take their symbol and use it for my product. That's why we have trademarks, to prevent people from doing that, from preventing people from coming in and taking away what you've built by creating a confusion in the marketplace. So when we file a trademark application in the U.S. Trademark Office, one of the things the examiners are most concerned with is what's called likelihood of confusion. They're trying to prevent confusion at the consumer level, so someone would think, oh, I'm buying this product, when actually they're buying something else.
Okay.
And those are the three primary ones you're going to encounter.
Okay, great. And is there some specific criteria that the USPTO looks at when they're looking at intellectual property? So like the one case from when I was in industry, the inventor lost his patent because they deemed that it was invalid due to obviousness. So what's some of the criteria to be able to get a strong patent?
The biggest battles at the U.S. Patent Office are based on novelty and non-obviousness. Novelty means, is it new? Has it ever been described before? Oftentimes, that's the smaller hurdle. In other words, no one has done exactly what you've done before. And while that can still be something that's debated during patent prosecution, that's oftentimes the smaller burden. The much bigger burden, you've experienced this yourself, is the obviousness burden. Because what an examiner will do is they'll look at your invention and say, okay, what you've invented, I don't have it identically here or identically here. But if I combine these references, let's say 2 other patents or scientific papers or what's on the web, if I combine together what's already known in the art, your invention would be obvious to somebody that's an inventor or a scientist in that area. So let's say you have an antibody with some kind of marker on it, fluorescent marker. He would say, well, it would be obvious to use this family of fluorescent marker that people have been using forever, and everybody has been making antibodies for a long time. So to combine them would make your invention obvious. And the criteria is, would it be obvious for a person of ordinary skill in that art to have combined these references? That's the more difficult battle. And if you think about it in your own life, it's also difficult because almost everything is obvious in hindsight. So, you know, the Wright brothers come along and the guy says, well, you just put a big fan on a glider. And that was actually a Wright brothers case, was very interesting that way. But the point is, you really have to focus on drafting the application so that you're going to be able to have a position to make good arguments that the invention wasn't obvious. And there are other criteria that the patent office will consider relating to obviousness, but that usually is the bigger burden.
Okay. So looking at a university or research institution, why would they care about intellectual property protection?
Some of these are my own personal thoughts, but one is, so we're at a medical center. Ultimately, what you'd like to do is find ways to treat people and make them well. And that could manifest itself in, say, a new drug discovery or treatment. If you can't get that drug out into the market so it's made and given to patients, the question is, have you really fulfilled your mission here? And part of the way you can fulfill that mission is to have someone say, you know what, I'm going to invest the incredible, and I mean incredible amount of money it takes to get a drug to market, let's say. And one of the reasons they might be willing to do that is they're going to get patent protection. The biggest analogy you see in the wintertime I can make is, you know, you have these cities where they get buried in snow and you go out at 6 in the morning and dig out a parking space. And then somebody comes in and pulls their car into the space you just cleared. You don't want to be that person with regard to an invention. In other words, you do all the work and then someone else just strolls in and says, thank you, it's mine. So the idea behind the patent system is you have an invention, you file the application, you get it through the patent office, you get patent coverage. Someone who comes to university looking at tech transfer office property says, you know what, that's an area we're interested in therapeutically. We're willing to invest and maybe help defray patent costs, et cetera, and talk about royalties in exchange for we'll develop this as a potential drug. And so at the end, the drug, let's say, hits the market, and they recoup their investment and more, but they protected themselves against having put all this money into it and someone else marches in later on. So it's really a way to get people to say, I will take the risk of funding this to get it to market with your goal in mind, which is if I can help, you know, hundreds or thousands of patients with this, the way to get it out there is to convince somebody it's worth pursuing, which means it has protection.
Okay, thank you. So talking about like the institutions, I know every institution has different policies. So maybe Jianbo, you could speak to this, having experience not only at Penn State, but also Oregon State. You know, can you talk a little bit about institutional policies and the roles of researchers about disclosing intellectual property?
Yeah, so as everybody in the university settings, so as once you sign on to be an employee of universities, by way of a BioStrategy Act, that university owns the intellectual property you're going to create, and one obligation is you have to report, and then we have to protect, and then we have to report to the government that yes, you awarded us this grant, and we discovered this, and we filed for patent application. That's actually an obligation. It's not that, oh, if I want to do it, I will do it. No, it's not. So if you discover something, it's our obligation to report it. So that's one thing. So I do want to add back a little bit about the IP protection. So when I go to talk to investigators, most of the time what I hear is that we're doing basic science. What do we do? The best benefit to the public, we are using taxpayers' money. The best way to do that is to disseminate the knowledge. So you should encourage us to publish, not to patent, to protect it, right? So this comes to the full circle. When you are developing a drug, as Pat explained it very well, if we don't have patent protection, then it's eternally lost because nobody's going to pursue it any further because they don't want to be screwed once it's successful, right? So if your goal is to get a drug into the market, then patent is a necessity. Of course, not every piece of research you do will be patentable, or we should seek patent protection. So by working with us, we can try to work with you to get this covered at the same time without a conflict.
Thank you. And so here at the Medical Center in the College of Medicine, our office sees a lot of medical apps and new diagnostic tools that usually do not fall under your typical patent protection. So how can they be effectively protected?
Apps are interesting. The first thing I would say about apps is keep in mind the expense and the time with patents. And by that I mean how much it costs to file and pursue the application, and also the lifetime of the patent. So I have a patent that has a 20-year term from its earliest filing date. Apps tend to have a lifespan of like 3 years, if that, 2 years. And so what I encourage people to do is, first off, go to the tech transfer office and tell them about your app, because there may be ways to protect it. It may make sense. There may be, it's possible that depending on the nature of the app, maybe there's a way to get a patent or not. That could be challenging. Or there may be a way to pursue a design patent that relates to the interface. Maybe the interface is really what's important about the app. Maybe the name for itself, the trademark may be important. Like everybody knows that app and you can build some important value around that. So my first suggestion is you talk to them about, here's the app, here's how it works. And they can do an assessment with the patent counsel to see if there's a way to approach patenting it, or maybe a design, or maybe trademark is the most important way. But the other important thing is just the business sense of, is this something that is really something you would best pursue through a patent anyway? There may be another business model that makes more sense for them when they're looking at an app.
Okay, that's great. And that's going to lead right into our next question with Steve. So Steve, as an investor, I mean, what are you looking for in terms of IP when a new startup approaches you? I mean, do you really just want traditional patents, or do you consider copyrights and trademarks? You know, what do you look for?
Yeah, and I think Pat, your point is really, really good in terms of software. And coming from an application background, we had a product that was an application, and we operated for 10 years and had virtually no IP protection. And I say that as a person who invested millions of dollars in developing the software, we virtually had no protection. But we were successful and we exited. So IP is important. To those of you who are involved with developing intellectual property, something that has value, something that you've put blood, sweat, and tears into, it's important. And protecting it is important. But I think, Pat, you used this word a little bit earlier, which is, what is your strategy to protect that? And to some degree, especially from a business perspective and as an investor now in other companies, I really look and say, what is the strategy to protect what you've developed, to protect what you've invented, to protect this property? And to some degree, I can say this as an investor and as having been through many rounds of investment, it's almost, I would call it maybe a passive formality in the software business. But I understand for many of you who are dealing with molecules and life sciences, that's not related. I mean, what I'm saying right now isn't necessarily related. What I can say, two principles that are really important, and I can imagine this applies to everybody. As an investor who's interested in the commercial applicability and success of whatever you've done, two big things when I look at IP protection. First is, we're looking and saying, what can we do to prevent others from jumping into your world and taking the customer share or revenue share away from what you're doing? And so we look at it from a perspective of a barrier to entry. What really is the barrier to others just jumping in and doing exactly what you're doing? And to the extent that IP does that, whether it's a patent, whether it's a trademark, and I think the point about copyright is a little bit, but certainly trademark as well. What we're looking for is, especially in the companies that we invest in, we deal with tech related, life science type investments. We're also looking for some protectable element to what you've done. Some protectable. It might be, if it's software, it may not necessarily be that you have a patent on a design or some utility of what your app does, but we're looking for something that is protectable. One of the keys in here, and Pat, when you explained it before, the idea, I think there's a huge misnomer, and some of us may have it, some of us may not, and that a patent guarantees me protection. It doesn't. You use the word, which is true. It gives you a limited monopoly. It gives you the ability to operate in this way, and it gives you simply the right to defend it.
The right to sue.
The right to sue, really. And so a patent is not a guarantee of anything. And so we, even as investors, understand that, just because you have a patent doesn't really mean much. What I really look for is you have some element that's protectable by what you're doing. And it may be protectable because you've decided to keep everything as secretive as possible. It may be protectable because just what you've done is so difficult to reproduce in the time frame, in the lifespan of an application, let's say. So there's a number of strategies. As an investor, I don't look and say, oh, well, you've got a patent. Well, that ends it. I'm going to give you $10 million. It doesn't mean that at all. It means, what have you done in terms of analyzing and understanding the implications of what you've built and how you've protected it? And perhaps you come to me and say, we don't have a patent, we don't have a copyright, we don't have a trademark, but here's why I believe our intellectual property is secure. And to that end, it makes the best business sense to keep it protected. So as an investor, primarily I'm looking for barrier to entry and something that's protectable. Because obviously I don't want to make a $10 million investment and then 2 days later somebody makes a claim or does whatever. So even though all that can happen, and we understand that, and I'm sure we'll talk about due diligence at some point as well. So
I actually want to dig in on something that you said, Steve. You said about trade secrets, and that's something we really haven't talked about yet. And we're really seeing that when it comes to diagnostics, which usually are not eligible for patents because you're just witnessing something that's naturally occurring. So how do trade secrets and having an investable company or product really play and work together?
Yeah, sure. I'll just say one thing. I can turn it over to Pat because I'm sure you can address this as well. But we talk about what is your strategy for protecting your IP, and some of it may just be keeping it quiet. I just want to keep it quiet. And just one real quick thing, there's a number of strategies. Patent is a strategy, copyright, trademark might be strategies, and just keeping it really quiet might be the best strategy. Because as I look and I say, what's the lifespan of your, from a revenue opportunity, from a commercialization opportunity, I try to look at that and I say, sometimes just keeping it secret is the best approach.
Trade secrets have always been interesting to me because they lend themselves to fun stories. So I went to Georgia Tech, and if you look across the campus, there's Coca-Cola World Headquarters. Supposedly the formula for Coca-Cola is in a bank safe somewhere, and two guys know the combination, they can't travel together, and there's all this, you have Kentucky Fried Chicken, whatever. The important thing to understand about a trade secret is if it's going to stay a trade secret, you have to have business policies in place that establish procedures to keep it a secret. Once the secret's out there, it's lost. And if you want to say, that guy stole my trade secret, you have to prove that you had policies in place to keep it a trade secret. The other thing I think is important to understand about trade secrets is science is moving so fast now. So I mentioned I worked for a client on site for a while. They're one of the world's biggest companies in analytical instruments. And so, you have this whole generation of kids that have grown up watching all these police detective shows where they have the mass specs and this and that. There's a lot of truth to that. In the old days, I could maybe make something and you're never going to figure this out. The analytical instrumentation is getting better and better and better. So one of the things you have to do with the trade secret is decide, is that a secret that I can maintain because the science isn't going to allow somebody else to figure out what it is? So I think with trade secrets, the key thing is you first have to define what is the secret I'm protecting and make sure there's policies in place so it doesn't escape out the door or whatever. And then, just maintain it, which can be tough.
Good question.
Yeah, I just have a question. As a medical research is where we get all our money from taxpayer dollars. Don't we have an obligation to, just like you were saying, that we have to all our information not keep trade secrets?
That's correct. So for us, as a university, it's very difficult. It might be possible if you don't receive any federal funding or state funding, so we might be able to keep it as a trade secret. But if your technology, you want to keep it as a secret, received any kind of federal funding, it's very difficult, if it's not impossible.
Okay.
Erika,
Yeah.
Another real quick story. You know, as a software person, one thing I was guilty of a long time ago, we had built something, and I'm looking around. You look at websites, you look at applications, and you almost even accidentally just incorporate some of the things that other people are doing into what you're doing. And it's not with, not malicious intent, but it is. And I got a call from a company by a team of attorneys, by a company that every one of you would know. And we had a nice little chat, and they talked about and they demonstrated why they felt as if we had infringed upon, and their specific thing was a copyright violation. And so, we had to go back, re-engineer. There was nothing necessarily, and copyrights are, I would say, more loose in general in terms of how you can enforce them or how you can prove, but they went through a series of steps to sort of demonstrate that. As an application developer, something that we had also done, and I'm saying this to say some things, if you can demonstrate that people have infringed upon it, and by the way, I'm not an attorney. I'll leave all the official attorney speak to the attorneys amongst us. But one of the things we did as a software company was injected a little bit of useless code, I'll call it, into our code. Completely useless. It did nothing. But it was in there because people could reverse engineer our software pretty easily. They could go in and actually take code right out of it. And if they took code that was sort of meaningless and actually incorporated in what they did, and we could demonstrate that, we actually had a situation where we did that. We were able to demonstrate they took code that was useless and demonstrate that they had sort of, technically we never got to the point where it really mattered, but they had sort of apologized, withdrew everything they did, and everything was good. But in terms of protecting what you do, there's probably a number of strategies that you and I, like I said, if in the life sciences space is a little bit different, but certainly in the technology space in terms of applications, even devices. So,
Thank you. That's a great point. Okay, so at this point, we've covered some of the basics. We understand what intellectual property is, how to protect it, how investors view IP protection. But let's go back to the lab for a moment. So let's say, I'm a researcher and I'm in a lab. I just had a breakthrough discovery. And now after coming to talks like this, I know I might have IP. So we're going to ask the panelists, what do we do? Do we publish first? Do we go and talk to one of you first? And which one of you do we talk to? Or have I already messed this all up because I should have talked to someone 6 months ago? So walk us through the process for a researcher.
Okay, so I will start since I'm in the role here. So I'm a technology licensing officer here. So what we encourage you to do is to, whenever you even just have an idea, just talk to us, right? So it never hurts to talk to us, and then the worst thing you can hear back is, no, that's too early. Let's wait for a little bit, right? So we don't want to create a conflict between our patenting process with your publication process. That's what we try to avoid. So the only time is we will ask you to delay because you tell me that you're going to present tomorrow. So we don't even have time to do anything. So we have to ask you either to delay or we do a rush filing for something that's not very good, right? So Pat probably hates that all the time. Oh, I have to do this in 10 minutes or something like that, right? So, yeah.
I was saying I'm 27 years old with gray hair, but yeah, that's always the tough part of being a patent attorney is the phone call or the email that says it's going to be disclosed tomorrow or whatever. It's worse now. When I started, the internet was still kind of iffy, and there's going to say, well, it'll be at a meeting in 6 months, or it'll be a preprint before the meeting, and I'd have all kinds of time. Don't have that anymore. What normally happens is if there's a decision to file on an application, we'll engage with the tech transfer officer and the inventors perhaps, and oftentimes we're asked to file a provisional application. And once we file the provisional application, people tend to feel a lot better. The caution I'd throw out there, though, is, once we file the provisional, keep discussing with your tech transfer office anything you're going to present or people you're going to talk to. Because the concern is, inventions are always in a certain sense a snapshot in time. So here's what I knew when I talked to the patent attorney, we got something on file. And sometimes 2 or 3 months later, you're like, oh, and what about this? And our big concern for you is that an inventor says, well, there's a provisional on file, and then he goes and discloses, important aspects beyond what's just on file. So I think it's important to have a really good dialogue with your tech transfer office to let them know, I'm going to go talk at this meeting or with these people or with this company, and maybe you want to have a CDA in place, a confidential disclosure agreement or something that protects a scenario where you're going to go beyond the 4 corners of what's described in that patent application. So everybody wants you to win. Everybody wants this to work for you and let you talk to people. But it's in your best interest, too, to make the team here at the university aware of what you're doing so they can protect you and the university as regard to further disclosures. And again, it's a different world. I mean, you type something on the internet tonight, it's all over the planet Earth. That's certainly not what it was when I started out. So you just have to work with that reality.
That's a lot of great points. I'm actually going to take my moderator hat off and put on a panelist hat for a moment, because, working in this office for the past 2 years, I think where we really see some successful patent applications is when we have a researcher come to us early. Sometimes we'll even have a researcher come to us when they're working on their R01. And we can even help them with that, because a lot of times if you have to have an innovation statement or a commercialization plan in your R01, they'll actually work with our team to help draft those statements to strengthen your grant application. But then that really gives us an idea of what you're working on, what is new, what is novel, and we stick with you. So as you have more and more discoveries, once we enter into that realm of, okay, it's now time to protect, what you're doing, we can time it right, because we've been walking alongside you for a year or more and understanding what you're doing. And that also gives us the ability to be watching what else is going on in the landscape as far as, is there other institutions also working in this space? So I'm going to kind of jump to that to kick it back to the panel. So when it comes to IP rights, is it like the first to discover, or is there something else like we hear about first to file? So if you have 2 researchers working in 2 different academic institutions and they have the same discovery, who gets it?
The U.S. used to be a first to invent country, and they had what were called interference proceedings to see who invented this thing first. It was kind of like a mini trial at the patent office. Years ago, the United States just decided to go to a first to file scenario. So now it's really who files the application first. And so that just reemphasizes the point that you should try and work with the tech transfer office early so you can get something on file. It's tough because some people say it's created a race to the patent office, but that's just the reality of it. So again, the earlier you can work with the tech transfer office, the better. I mean, usually, like I said, they file a provisional. It's not unheard of to file a series of provisionals as the invention develops before you have that 1-year deadline from the first provisional to convert into regular application. So there's a lot of procedural stuff involved, but because it's really who files first, you should really start that dialogue early.
Yeah, so I want to add on to that. It's first the inventor to file. Okay, so if you invented something, you picked up the phone, you talked to your friend filed. If you can prove that he or she stole the idea from you, then you are still the owner. Okay, so that's why the communication with us is very important. If you work with us first, we have a record for it. Okay, if we can prove that the other party just basically just stole your idea and just beat the clock to file, then we can still get our rights back. So.
Yeah, I just want to add to that, you don't want to have that challenge. You don't want to have to be in a scenario when you're proving they stole it from you. So again,
yeah, that's always difficult, of course.
Okay, so on that point, I mean, I think we have a couple things here. We have Steve's perspective where just don't say anything. keep it to yourself. So we have that. But if there is a person that you need to talk to, either about your invention or about your discovery, what other avenues can you go down? I think you mentioned confidentiality. So what would a researcher do if they do need to talk to somebody else about their invention?
I would just suggest again, they talk with you because there's usually policies in place to say, we realize that science is collaborative. It may be very helpful to speak to someone at another institution, and we have template agreements in place for those types of things. So just have that conversation, understand how the university approaches you working with a collaborator, because, as we may discuss later as to inventorship, there may be situations where both institutions could end up having rights, and you want to kind of clearly delineate who's telling who what and when early on. So again, that's not a problem down the road.
Yeah, so for us, we strongly encourage you to talk to your colleagues, okay? As long as they are Penn State employee, you don't worry about anything, okay? You don't need any agreements to talk to anybody within Penn State system, okay? So as an employee, we all assign our rights to Penn State, so everybody was treated equally, okay? So we encourage you that, and most likely, okay, I say this because we sit high on, so you probably just, for example, College of Medicine, your colleagues in College of Medicine, you probably don't know a whole lot of what's going on in engineering and pharmacy, other departments at the UP. So, but we sit on top, we have our own database, we see all our technologies. So when you disclose something to us, we can suggest you, okay, with both permission, okay, of course, we are not gonna link you automatically. If we see your technology, we see another technology, we see there might be a synergy in between, we will get your permission, we'll get another collaborator's permission to allow you to talk, okay? And then you can just go talk to them. It's always good. I mean, I talk to faculty members, some of them worried about the contamination of the inventorship, which has its own right to worry about. But again, if somebody's going to help you to perfect your technology, I think that's worthwhile to just protect something that's not perfect. Okay, so that's why we encourage you to collaborate. And it comes to, if we cannot find any collaborators within the Penn State system, then, or if you insist that your colleagues at other institutions might be better suited for your collaboration, then we can set up agreements for you to talk. Okay, so just please don't automatically pick up your phone and talk to your colleagues outside of Penn State, because the IP might be lost by you picking up the phone, right? So call us first or email us first, and we will try to do whatever we can and not delaying your process, but at the same time to protect what you have.
Okay. And as far as our office goes, I mean, we do have some very simple agreements from a standpoint of confidentiality agreements, especially if you're talking with industry. Those are always good to have in place. And even material transfer agreements, a lot of times that will establish the materials that are being sent, who has commercial rights, who owns what materials. So those are really good agreements to have in place anytime you're working with anybody outside this institution. All right, so let's take the scenario that a researcher has already published. They published, their article 6 months ago, and they forgot to contact the tech transfer office. Have they lost all of their intellectual property rights?
They've lost their rights in basically the rest of the world, pretty much. It's the United States, there's a grace period, so they can still file. That is the main reason why we encourage our clients to disclose first to the tech transfer office, because when they disclose or publish and it goes out into the world, you've lost rights in basically the world except for the United States. Why is that important? It's important because certain, let's say you want to, let's just use a drug. The pharmaceutical companies, when they are going to pursue something, they want to be able to pursue worldwide rights often for major countries. And if they come into a situation already crippled by having lost rights throughout the rest of the world, it's much less likely they're going to be interested in talking with you. So the idea is, get that provisional on file and then move from there. But if you've already disclosed it and it hasn't been over a year, there's still a chance for us to pursue it in the U.S.
Yeah, so I want to add on that. So there's always a good side and a bad side, right? So don't take it that I encourage you to publish without talking to us, right? So we will never do that. So we always encourage you to contact us first to seek protection first before you publish. But again, if due to whatever reason you published, and all of a sudden that you get an influx of inquiries, that always means you have hit on something that's very important. Then you should really contact us. Okay, so because for us, the major decision is not how interesting the science is. Unfortunately, we are not here to publish your stuff. Basically, we are trying to market your technology to make money for the university. Okay, so number one for us is the market. If there's no market, no matter how interesting your technology is, we will not going to pursue it. So that's blank. So market is, if you have a lot of interest, either from your colleagues or from industry partners, to pick up phone, hey, I saw your publications, can you be a consultant to us, or can you teach me to do this, and how does this work? It's very strong indication that you hit something that's very important. It's never too late to disclose to us. So we can protect it. We can have some rights in the US. And again, the science is always evolving, right? So it might be something different coming up along the line of research that has not been published. But it's along that line, then we can still pick it up and then to gain international rights. So.
Yeah, just one more quick thing. I think it's in my points earlier about a strategy around IP protection. Sometimes a trade secret route is a better route to go, certainly depending on certain things. But overall, everyone should talk to somebody. You absolutely have to talk to somebody, because whether it's a university environment, obviously coming and talking to you about commercializing research, et cetera, or you've invented something in your home and you're not sure what to do, and you go and talk to someone like Pat who says, hey, maybe there's nothing you should do. Maybe you should just get your product to market and go from there. Someone a long time ago once said, especially in the product side, let's say apps or whatever, market dominance is an important thing. We talk about getting your product out there. If I get my product out there and it's dominating, that's in and of itself a pretty big barrier for some other people to try to come in and take. So I don't need to necessarily spend $800,000 protecting it on some, with some patent that may or may not be defensible in any way, shape, or form. So
that's funny. One of the first clients I ever had, I was just starting, and he taught me a lesson. He said, it's the firstest with the mostest.
Yeah.
There's that notion you get out there and dominate that space, which is where trademarks can actually be more important.
Yeah, exactly. And actually, so I think in all that, as an investor too, sometimes, and I understand an environment, there's certain constraints in university environments with policies, et cetera, there may be some constraints. But either way, I know from my perspective, absolutely should be talking to someone to evaluate it from a university policy perspective, and from my perspective, a business perspective, because some people may look at it, and whether we talk about it or not today, it's an important fact that there may be some business elements that you say it would drive me in one way or another related to IP. So.
Okay, thank you. So to that point, understanding a lot of times getting first to market where you have something like an app, which you can move in very quickly, versus something like maybe a new therapeutic, which that's a very long road. It could be a decade or longer. Why don't we talk a little bit about the whole standpoint of intellectual property protection and how long it takes to get a patent, because that could definitely drive a business decision as well. So Pat, can you speak to, from the time we file a provisional patent, what are we looking like as far as timing? And I do have a little graph to show everybody here too.
Well, it's years. I'll just say a few things. One is it varies by examining group usually. So some groups are more backlogged than others. The other thing is the patent office has been focusing on reducing pendency time. So they've been trying to reduce the amount of time a case is in their hands until it's decided it's going to issue or not. So they've been trying to drive down pendency. I don't know what numbers you have ultimately here. They're trying to get to less than 2 years. The other thing to keep in mind is in the old days when I started, the patent term started when the patent issued. It wasn't measured from when you filed the case. So it's in your best interest to get the case issued in a reasonable period of time. Because if you spend a huge amount of time in prosecution, there's not much patent term left at the end. So there's a much bigger incentive now to just be efficient yourself. Because when the patent office, for example, gives you an office action, you got 6 months to respond to it. In the old days, people would take 6 months. Now, not so much, because that's patent term. And if you think about $1 billion drug, that can add up to a lot of money at the end when the patent terms run out. So there's a newfound focus on efficiency, both from our side, because of the patent term, and from the patent office, because there's a realization that part of what makes this country competitive, arguably, is our patent system, and it's not in our country's best interest to have these things hang at the patent office for 5 or 6 years. So let's get it done, as they say.
Okay, thank you. So a lot of times when you start this path, I mean, you file a provisional, you have 12 months before a decision needs to be made. And at that point, you have to decide, are we going to file a PCT and go after foreign rights, or do we just look at US rights? Can you talk to us a little bit about what goes into making that decision and the costs that are involved with that decision?
Usually what happens is that you'll file a provisional, and within that year, it's like one of those starting pistols at the Olympics. They're off to the races at tech transfer to find someone who would like to have a license. And part of the reason for that is to help with patent expenses. And a big part of that is the cost of foreign expenses. Okay, we're talking tens of thousands of dollars here at least for foreign programs. So, 10 to 15,000 EPO, whatever. So the U.S. costs aren't so much, but if it's an international program, you really want to have the money kind of lined up. So what tends to happen is at that 1 year anniversary, I can file just the U.S. or I can file a PCT designating the U.S. So I can get more time to try and line up the money. But really what the race is to line up interested parties so that you can have someone who says, I'm going to foot the bill for a foreign program down the road potentially. So around that 12-month period, you're trying to decide if there's really interest. The other thing is, as I mentioned before, these things are snapshots in time. So what I knew when I filed the provisional, I may have come up with more data, more information about the invention. It helps me flesh out the invention even better, because you can imagine this as a kind of a storytelling to an examiner. An examiner is just like you and me. They'd rather hear an interest. You're in a cubicle with a stack of applications like this. You'd rather hear a nice, interesting story. So if you have a nice, here's data that shows this thing could work therapeutically. Here's more information that explains how we think we can apply it to various other diseases, whatever. It's always best to develop that. So ideally what happens too at that 1 year anniversary is, well before that 12-month date, there's a discussion to see what additional information could go into the application, both a US and a PCT, to kind of develop the technology a little bit more, and also potentially help in discussions with these potential licensees who might foot the foreign program. Because if they see more data or more expansion, this might be a platform technology just versus this one thing, they might be more interested in having a discussion about helping to defer the costs.
Thanks. Jianbo, can you speak to a little bit about institutional policy from your experience at Penn State in Oregon, as far as how does the university kind of look at this timeline? Do they have some metrics that they put in place? And I know we have some pretty specific, policies that we have, but if you could even speak to some general, so the researchers could kind of understand how this path works for them.
Sure. So the clock starts, we file, right? As Pat said, the patent term starts because we have to convert at the 1 year time. So that's when usually at 1 year time, the cost transition from what we call a provisional, basically we cover everything, to a PCT, which is a application. Basically, we let the world know that we want to reserve the rights to go into every country we want to, right? So from the provisional to PCT, it's a low cost, right? So usually the bar is very, very low. So if you have some technology, and if you do have resources to work on it, and you are still working on it, and there's no significant barriers that we uncover, usually that's enough for us to move forward. And then it's at the national stage, so that's the third stage. That's when the application really got examined. So that's about a 30-month start from the start of filing. That's very expensive. It gets very expensive. In the United States, it's cheaper, but then if you want to go to other countries, it's very expensive. So it's a very, very high bar to overcome if you really don't have any interest. We tried to market it and nobody's taking the bait, or something else that may I don't know, decrease the value of the technology. Then that's a decision we have to make. We are going to abandon together, or we just keep the rights in the US. So every university has a very, very limited patenting budget. So for Penn State, we only have $2 million. We have about, I don't know, 800 million or so research. So we have a lot of technology presented to our office. It's very difficult to pick which one to protect, which one not to protect. So that's why we work with you. So we present our argument, and you counter our arguments to basically we reach an agreement if we're going to move forward or not. So we make a mistake. Everybody makes mistakes. So don't laugh at us when we make a mistake, because we are human, right? So as long as we make a decision with you, then hopefully we can carry on. So hopefully we make less and less mistake, and then we get more technology covered.
Thank you, Jianbo. And so just to kind of reiterate, so that's when it's really good to bring the tech transfer office in early. So, that, because once that filing date starts, that really does start the clock. And from there, you have 30 months typically to then the university has to make the decision, okay, we're not going to continue to fund this, and we're going to abandon. And once you abandon, you're never going to be able to get those rights back. So if you then meet a company that wants to license your technology at 36 months, those rights are gone. So that's when it's really good to really making sure that you're getting that timing right, and you're actively working with Jianbo and the other licensing officers, or the licensing officers in your tech transfer, so you can identify a potential licensee to maintain those rights moving forward, that we don't get in a situation that they need to be abandoned. Dr. Tsai.
How do you decide which foreign country that you want?
Yeah, then that we have to get the information from the inventors. So they know the market size, and then we have our own database. We get input from you, and then we have our own database. We can get, even if it's a very important decision to be made, we'll even pay to get a white paper to see exactly what a professional write about where the market is, and then we'll go for that. So I do want to add a quick point. Okay, so it's not U.S. rights is inferior or anything. For us, for the College of Medicine, U.S. rights is the most important one, because we don't have a single payer system. So if in Europe, they negotiate it because they have the public kind of a benefit system. So they won't negotiate with you if you charge too much. In U.S., actually right now it's at a will. So as long as somebody paying for it, we can charge that much. Okay, it's bad or not, I don't know. It's not up to us to determine, but that means if we have a successful drug, even we only have US rights, it's very significant. Okay, don't want to downplay that. Okay.
Yeah, it's a very important point. I've encountered this many times at institutions. A lot of times, I think it's an American thing. We forget the size of our market versus the rest of the world, because some of these countries, the population is less than Philadelphia. I mean, so just keep scale in mind, because it is such a big, huge economy. And even look at who our trading partners are. So Canada's very big. So you tend to, I guess I take it as an American issue that we think,
And I know, and one thing we always look at too is enforceability. So if you are, going to get IP rights in India and someone decides to invade those rights, how enforceable? Are you going to travel to India and really fight for your rights? And will you even have, the ability to do so, or will their government automatically side with their own citizens versus you? So, you always have to manage that as well, as far as where, this comes down to, Steve keeps saying, business decisions, like where do you want to spend the money to really pursue those foreign rights?
Yeah, it's a good point too, because some of them, they don't really have a court system for patent issues. They got other more pressing issues, or there's a policy issue in that country, or what they consider a remedy that's good is, not worth us investing the time to fight it about. So that's another issue to keep in mind. What means if you win in that country, what does that really mean?
Yeah, I think earlier you said if you get two goats, so. Okay. So let's talk about inventors and inventorship a little bit. So, one question that we'll get, when we're receiving a new invention disclosure, we'll receive an invention disclosure where we'll just have one person listed, that they are the inventor. Others, they'll put every person in their lab. So is there some specific criteria from the USPTO on who is an inventor, who is not an inventor, and explain some of that to us?
It's really about the conception of the invention and what ends up in the claim. So there are two extreme scenarios. First thing I'll tell you is a patent is a legal document. It's not a scientific paper. They're different things. So someone who should be on a scientific paper wouldn't necessarily be on a patent, for example. The danger one honestly sees in academic institutions is two ends of the spectrum. One is the guy who's head of the department ends up on every invention disclosure because he's the head of the department, but he didn't necessarily have anything to do with the invention. And at the other end of the spectrum is the world's greatest lab tech who never gets enough credit, and they're on the invention disclosure, but they were just following the instructions, let's say, of the primary inventor. So the inventor who had the conception of the invention as it's manifested in the claim said, lab tech, do these following experiments. And they do it, and they're a great person, they have great hands, but they're not an inventor necessarily. Which leads to my next point, which is disclose everybody who honestly might have contributed to the claims and let the patent attorneys sort it out. That's one of our more messy and challenging jobs, is to directly confront who contributed and who didn't. If you purposefully leave off someone who's an inventor, the patent can be unenforceable. So you really need to be honest about who contributed. The other thing that's a rarity, but it does happen, is in the course of prosecution, you can even lose claims, which might affect inventorship. So that person's contribution disappeared during prosecution or a restriction requirement or whatever, because their contribution is no longer there in the form of the claim. So especially with a provisional, it's an early part of the process. Have a discussion who contributed and what, an honest story about it. And then oftentimes if there's a dispute, the patent attorneys will be asked to interview or at least talk to the inventors and try and get a hand on what really happened.
Okay, so if you have an invention and you definitely have one individual that took the lead, it's their predominant idea, but they had the support of two other individuals that they wouldn't have got to where they got to without those other individuals, but they took a more minor role. What does that look like as far as inventorship? Do they all have equal rights to the invention, or does one have more rights than the others?
I always avoid getting too fuzzy on these discussions because it's really about conception of the invention and what is in the claims. So if they help me, I got to go step back and say, what did help mean? Did it help me get to what's actually manifested in the claims as what the actual invention is? Or again, are they a lab tech type scenario? So again, it's really a situation where you got to dig down and say, what was the intellectual contribution? What was their part in conceiving what ultimately I'm trying to protect here? Because, it has to be that kind of analysis. Otherwise, you get creep where everybody's an inventor all of a sudden.
Okay, thank you. So let's look at exactly from a researcher standpoint, what you need, your enrollment in this process. So Jianbo, I'm going to start with you. So what do you actually need from a PI or an inventor, to get this whole intellectual property protection process started?
Yeah, so to start as early as possible, and disclose as detailed as you can, so we can do a good assessment and then can suggest a better path forward than we only have a bare bone disclosure. Hey, this is an idea, and then we do have an invention disclosure form. Most of the time, we only get a bare bone, a few sentences here, a few sentences there. That's very difficult for us to do anything, because if you want to have a fair assessment, you need to provide us with a fair amount of content. So to start the process early, to discuss with us, communicate with us constantly, and then in the process disclosing more details to us.
Pat, when you're speaking with the PIs and the inventors, what are you looking for?
It's very helpful for us to have a discussion with them about, basically what's the nature of the invention, why they think it's novel, and very importantly, why they think it's not obvious. And also for the purposes of our duty to the patent office and just to get up to speed, what's the most relevant art that's out there? Ideally, what happens is they let us know the most relevant art so we can look at it in the process of preparing the case as well. And we have a duty of disclosure to the U.S. Patent Office to say, U.S. Patent Office, here's what's out there that we think is the most relevant for the purposes of your examination. Believe me, if you don't do that up front, it's going to happen in litigation. So the idea is make this thing robust by confronting what could be a problem down the road, like an obviousness problem later on. If I had a chance to, let's say there's art out there and I don't know about it when we draft the case and then it gets litigated or whatever, you could be in a very bad situation. So the idea is let us look at it. And one other element I'd add to that is when we get a chance to look at other art and discuss it with the inventor, it may open, additional ideas for the inventor as to maybe other things you could be looking at, even other utilities for the invention. So it's a win-win if we know what's out there and we can have a good discussion about it.
Right. And Steve, when you're talking with entrepreneurs or CEOs of academic spin-outs, what due diligence do you conduct on that intellectual property?
Yeah, what's interesting is, and I appreciate that Jianbo said it first because then I don't have to, but you guys are really focused on what's the marketability, what are the revenue possibilities for the university? What due diligence we do is we simply say, well, two things. First of all, we're gonna try to understand what have you done and whether it's in cooperation with you folks, whether it's in cooperation with your patent attorney or your intellectual property attorney, what due diligence have you done to determine what's the necessity of what you've done? Did you need a patent? Did you need this? For what was the business element to what you did and why you did it? And then we say, okay, if you believe that it was really absolutely necessary for you to have a patent, then yeah, we'll look at the patent docs and we'll maybe talk to your patent attorney just to get a sort of general understanding of what's going on. I wouldn't say investors do like this extreme due diligence. They're going to want to see things. They might want to see trademark notices. They might want to see, patents. But in general, really what the due diligence is about is from a business perspective, did it make sense? Did it help you? I could tell you stories. I can't tell you how many entrepreneurs or startups that have come to us and they said, well, we just spent $45,000 in 2 years of time developing this and getting it patented and doing this. And they have no idea who their customer is, or they have no idea what they have, or they may have no idea that their revenue opportunity has sort of passed. Maybe the market sort of passed them while they were off busy doing this. So some of the due diligence, obviously there'll be some sort of boots on the ground, just looking at what they've done. If it's necessary and they can demonstrate it's necessary, we're going to look at the actual documents, things like that. But beyond that, we're really looking for the justification behind what they've done.
Thank you. So I was going to shift gears at this point and just share some of the common concerns and questions researchers express to our office when they're coming in disclosing intellectual property. So one question we hear frequently is, what if I leave my institution? Can I keep working on my research or my intellectual property? Or does that stay here? Or can I take it with me? So how does that work?
Yeah, so the simple answer is yes. So don't worry about a thing. We will take care of the paperwork for you, so you do whatever you want.
There you go. That was easy.
There you go.
Next question.
Okay. Another question that we often get is, can I continue to apply for federal funding if I disclose my IP? I'll give that one to Jianbo. So can they continue to get federal grants if they are not pursuing a patent?
Okay, this is a thorny issue, right? So that's the issue that it's very difficult to give back to the faculty members. So as long as you don't start your own company, then it has no bearings on you. But once you started a company, no matter your company is doing what, once you file your paperwork, that means you started your company, then you really, really have to keep your book clean. What is your company doing? What your research is doing? Okay, you cannot use your federal funding to do anything related to your company. That's very serious. Okay, so that's what I usually recommend to my faculty members is, if you believe you're going to start a company, you should wait at least the last moment to do it, okay? Because before that, it's still research. Even though you have full intention to start a company to develop it, but once you start it, then you really need to keep a clean book to make sure that this side is my research, this side is a company. You can apply for grant that's something similar to what your company is doing, but it cannot be exactly the same thing. So basically, the federal grant cannot in any way to contribute to the success of your company. So that's not allowable. So that's very difficult.
Well, let's continue on that difficult conversation. So when you are looking at funding, though, are there other avenues? So you have started a new you've spun this technology, this intellectual property into a startup. Is there other funding available either at the federal level or even outside the government that can continue this proof of concept and advance this technology?
Yeah, so there are other mechanisms. So the SBIR, STTR can get you, so you can still apply for federal funding to do your research, to do your company work. That has nothing to do with, but you cannot just use both federal funding and your federal funding to do both your research work, supposed to do your research work and contribute it to your company work, right? So you start a company, there's small business grants that just allow you to do stuff for your company. Of course, you can do sub reward to your lab if there's some part of the research has to be done in the lab. That's doable, right? So, but don't commingle. Yes.
Yeah, no.
You can't be a 51% owner as a professor in a company and take your R01, which is given to the university, not to you, and use it for your company. But if you're a professor and you start a company and you're a 51% owner, then you're likely to have a full-time faculty member. Then you can get an SDIR, which goes to the company. So the differentiation is the monies that come to the university in your name to do your research cannot be used forward your company. But an SDIR can go to the company, and a piece of that can go back to you if you're not a 51% owner of that company.
That's correct. That's correct. So
it's really important to get those distinctions, because I think some people have a misconception that they can start a company, be a full-time faculty member, and go out and get an SDIR student count.
Right.
Yeah,
that's correct. Yeah.
A great point, Mel. And that's why we also encourage, to come and talk to our office as well. If you're looking at forming a startup, and as far as what applications and what other federal funding is available, we actually have a whole team of people that can help you like that. And we actually partner with Ben Franklin and Innovative Partners with Kelly Wylam. She's great as far as walking you through some of that, but in university policies as well.
And I'm just curious, how many people here are familiar with SBI, STTR programs? So not, okay, so yeah, that's a great point. That's the distinction, I think. And, I'm more familiar with SBI, STTR side of it. So, understanding the commingling of your research dollars related to your, faculty position versus, or research position with the university versus small businesses trying to, do more research or do more discovery with federal funds. That is definitely possible, so.
Well, let's move away from federal funding for a moment. So like with Ben Franklin and the Life Science Greenhouse and the other institutions we have here and other mechanisms we have in PA, so if you do take your intellectual property and your technology into a startup, what other funding is available to keep that technology moving forward?
Sure, you come talk to me. After they've talked to you guys and gotten all the things they need to get done with you guys, you come talk to myself, you talk to Mel, you talk to folks who, and the assumption, let's just take, you're starting something, you've invented something, and you've got the appropriate protection in place. And now you come and talk to someone like the Ben Franklin Technology Partners, who gets behind different companies, all sorts, tech related, medical devices. We do get involved with molecules as well. Certainly there are other investors that are more specific in that area. But you may need to come and you may be very early stage. You need $100,000, you need $200,000 sort of to get started. And we would consider that pretty small in terms of sort of initial getting off the ground investment. But there are a number of very early stage investors, Ben Franklin, where we're more, we are I'll call it a program of the state of the Commonwealth. And so we have some missional perspectives ourselves in terms of our investment. But you can come talk to Ben Franklin, talk to Life Sciences Greenhouse, pursue SBI or STCI. I know those are federal funds again, but there are definitely opportunities out there. And there are investors. I mean, certainly certain, maybe I'll call them slightly not angels, we'll call them VCs, who may want to get involved a little bit earlier in what you're doing. It's always a challenge because a lot of the things that I'm sure many of you doing here, many of the things that you're doing here are very expensive to get it to market, and it's time intensive. And not every investor has the stomach for waiting years and spending hundreds of thousands, if not millions of dollars just to get it to market. So there are strategic partners that may be interested as well. Obviously pharma, different things that may be better suited for helping you bring your product to market.
Right, excellent. All right, I'm going to go the complete opposite end of the spectrum. The other comment that we a lot of times hear is, I don't care about the commercialization component. I just want my idea to get out in the world to improve health and make patients better. So I'm not going to file IP. I'm not going to worry about it. I'm just going to publish, and some pharmaceutical company will grab it and run with it. Does that happen?
No. So if you don't have, we discussed this before, if you don't have IP protection, it will not happen.
Certainly in this space, someone creates an app and just gets it out there in the market, and they want to go out there sort of called running naked in the market. They can go ahead and do that. Some people get out there, they'll have an app, maybe they haven't have some protection. They come out, they do their thing. Maybe another company comes along and right behind them and does it, maybe slightly tweaked, slightly different enough so that there's not perhaps, inappropriate competition or infringement. And maybe they dominate the market. They don't have much protection, but they dominate the market. Someone once said the first mouse sometimes doesn't get the cheese. The first mouse gets the trap, and the second mouse gets the cheese. Especially in certain products, certain applications, that is the case. First one out there may have good technology, may have a good approach, but they may not end up being the most successfully marketed and successfully marketable company out there, and certainly from a revenue perspective. So I think all of this, to the degree that many of you here are researchers, I think to that same degree that you're excellent in what you do in that, you've either got to become excellent in terms of from the business perspective, the commercialization element, but also partner with folks who are experts in this area to be able to ensure that everything. And Erika, you had said, well, what if you don't care about some of this stuff? What if you just what if you're just doing this from a missional perspective? There are some things, obviously university policy and what Jianbo said might dictate many of what you do, but you can be out there and you can be in your house and invent something and put it out there for the world to have. And that's great. It depends on what your personal goals are. You may never get investment in what you're trying to do. You may be misunderstanding the fact that sometimes commercialization is the best route versus, let's just say, being just trying to do something good you may have better success, more reach through commercialization than you would just trying to get it out there by yourself.
Those are some good points. And I think going back to the life science space versus the app space, the one thing, we haven't talked about today, but it is also a very valid point, is also that we have a whole regulatory system. So when it comes bringing new drugs to market, bringing a new medical device to market, there is a very stringent regulatory process that has to go through that costs lots and lots of money, even putting clinical trials aside. And, from that standpoint, that is going to take lots of investors, and they're going to want to know that, their asset is protected, and they're going to be able to monetize and get a return on all the money that they've invested in. So that intellectual property component is very important through there. So that is one conversation we will a lot of times have with a researcher. So if they have a new algorithm, they have some open source that they want to put out there to make the world better, sure, great. That's have at it. But if it's a new therapeutic, if they have potential for a new drug, a new compound, just to put that out into the world, to have a company come and take it without intellectual property protection pretty much won't happen because the cost is too high to get it to market. So, all right, at this point in time, I would love to open it up to the audience to see if you have any more questions. Okay, did we have any from online?
Yeah, there was one that came in from Temple. It says the question about faculty leaving is a bit harder here at Temple. We typically will connect with the TTO where they are going to get an inter-institutional agreement, as improvements will belong to them, and licensees want access to the inventors. Any thoughts on this?
Yeah, so that's our usual procedure, right? So when faculty is moving, then we establish the so-called interinstitutional agreements to cover any future inventions coming out of the background invention we already have. So we will get that established, and then we will hopefully get a clean record of what materials have been transferred over from our institution to the next institution. So we cover that because you might have complications with the future inventions.
All right, thank you. All right. Well, in conclusion, I just want to state, there are many benefits to intellectual property laws and frameworks, protecting the research discoveries and inventions inside of academia and research institutes. I mean, they can strengthen your lab, your department, your institution. They can also capture, the potential for commercialization. And they also encourage academic industry partnerships, which can lead to sponsored research funding. So, having these talks early with your tech transfer officer is really beneficial, not only to protect your intellectual property, but it can benefit your lab all the way up to the institution itself. So thank you so much for your time and attention today. We appreciate it.